Greetings, squirrel friends of the world. I hope you all are having a wonderful weekend or weekday, whatever day you're watching this. Right now it is August 3rd, 2024 when I'm recording this video. And I've had a number of people ask me, what's going on with Murdaugh? You know, is there anything like where is it at? Like what's happening? You know, because this is just the case that keeps on giving. The first what I wanted to do is just kind of remind everybody where it's been at after the hearing with Chief Justice Toll and, you know, hearing from all the different jurors and Chief Justice Toll denying the motion for a new trial, given there's that split. We've talked a whole lot about the split between the federal courts and the state courts in terms of the two prongs that you need to look at when deciding whether or not to grant a new trial. The first question that you know they had to answer was there any type of involvement by a court official? Which in this case it was Miss Becky Hill, and that question was answered. Yes, she did interfere. She talked to them. You know, they heard different things. The different jurors heard different things, but that's the first question. And then the second question was, did that impact your verdict? And of course, we had a really suspenseful moment where initially Juror Z had said yes, and then she kind of walked that back and said that the bigger impact on her verdict was the evidence in the trial. That was a nail-biting moment for everybody watching. I actually screamed and scared my dog Frodo, thinking that, oh my gosh, that's it, he's going to get a new trial. But anyway, if you haven't seen that, I do have a video covering that hearing in one of the Murdaugh playlists. And so in the federal system, right, with that split, like I mentioned it before, with the federal system, there's really only the one question, and that's, was there interference? And if the answer is yes, you get a new trial. It doesn't mean you're not guilty. It doesn't mean your charges are dropped. It means you're granted a new trial, okay? Automatic mistrial, okay? So part of what the defense for Alex Murdaugh was kind of arguing was, you know, they were really relying heavily on the case law that supports that. However, the problem is that Chief Justice Toll is bound by what the South Carolina Supreme Court has decided. Now, why is this? When we talk about mandatory binding authority, for everywhere in the country, regardless of if it's state or federal, anything, the highest law of the land after you have, you know, your rules and your statutes is the U.S. Supreme Court, okay? So here's the thing. This issue of these two questions, right, and when do you grant a new trial, has not come before the U.S. Supreme Court before, okay? So the federal cases that have weighed in on this issue come from the circuit court, which is the Court of Appeals when it comes to federal trials, okay? So it's the circuit. So they were looking at the circuit court case law from federal trials. So the issue is that is not binding to the state trial court. This is why my thoughts are that this will make its way to the U.S. Supreme Court because, again, this has not been decided by the U.S. Supreme Court. And that's why this is why it's an issue. So, therefore, because this issue has not come before the U.S. Supreme Court, the mandatory binding authority before Chief Justice Toll at the trial court level, because remember, she stepped in to replace Judge Newman. This is still that was still a trial court issue. It was still within the trial court's discretion. And she said as much at the hearing. So her mandatory binding authority, considering the U.S. Supreme Court has not weighed in on this, is the South Carolina State Supreme Court. And the South Carolina State Supreme Court, okay, the case law there is that it has to show that it would impact the verdict. Right? That's that second question of the two. So she has to follow that because it's mandatory binding authority, okay? So, as expected, that decision is moving through the appellate process. However, prior to all that going down, right? So the trial ended, he was convicted, sentenced, found guilty, and then as standard, right, which is just, you know, you get your automatic appeal for sentences such as this. So his attorneys had already filed an appeal for his murder conviction, right? Now, when they came out with this breaking news of this after discovered evidence of jury tampering, right, they were able to have their initial appeal paused, right? Because there's a time clock on all of these things. That was all paused in lieu of all of this. Because then the idea is, well, if the outcome of this after discovered evidence of jury tampering, if that did result in a new trial for Alex Murdaugh, then all of the rest of that is moot, right? The appeal is moot. Like that doesn't matter when you've got this other issue. And that having been decided by Chief Justice Toll and is now moving through the appellate process, it means that they're back on their original clock for the regular appeal for the murder conviction. So the important thing to note is that there's two different appeals going on for him. One is appealing Justice Toll's decision about not granting a mistrial. So that's moving through the state appellate courts, okay? That issue. And then there's the initial appeal that was started prior to the after discovered evidence, which is just your standard run-of-the-mill, right? It's just like whatever we hear in every case, an appeal of the conviction of the murders. Two separate things. Okay, so now let's take a look at this. This is coming from Court TV. This is just a little synopsis here. So it says, the defense team representing disgraced attorney and convicted killer Alex Murdaugh has filed new documents asking South Carolina's highest court to take a look at his appeal. So this is from July 12th. And so the appeal that they're referring to here is the appeal of Chief Justice Toll's decision, like we were just talking about. So he's appealing to the South Carolina State Supreme Court on her decision, okay? Shortly after Murdaugh was sentenced, his attorneys called the guilty verdict into question and accused then Hampton County Clerk of Court Becky Hill of tampering with the jury by making comments implying Murdaugh's guilt. The allegations prompted a January hearing where retired Chief Justice Jean Toll denied the bid. And then here's a quote. Quote, the circuit court nevertheless denied the motion for a new trial. Murdaugh's attorney said in the motion, reasoning that there is no presumption of justice from tampering with jurors during a trial matter pending before the jury, and Mr. Murdaugh failed to prove that Miss Hill's comments actually changed the jury's verdict, end quote. Right. So, but it says this week, Murdaugh's attorneys filed a new motion with the South Carolina Supreme Court asking them to bypass the Court of Appeals and take up the issue themselves. The central issue, Murdaugh's attorneys argue, is whether Justice Toll relied on incorrect case law in deciding Murdaugh would not get a new trial. So this is why we went over all that background. So Justice Toll relied on South Carolina law and had determined during a pre-hearing hearing that Murdaugh would bear the burden to prove actual prejudice from the jury. So in order to get a new trial from her, they would have had to show that the tampering from Becky Hill changed their verdict. That's why, again, it was so suspenseful when initially Juror Z was like, yes, it did. But the U.S. Supreme Court has previously held in unanimous rulings, quote, that in a criminal case, any tampering with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, and the burden rests heavily on the government to establish that such contact with the juror was harmless. Murdaugh's attorneys are thus asking the Supreme Court to step in and determine, quote, whether most federal circuit courts have misunderstood Supreme Court precedent, end quote. In their argument asking the state Supreme Court to pick up the case, Murdaugh's attorneys emphasize that their client's case is one of great public interest and include in their motion a comment from somebody, I don't really give a shit. By the way, I have tried to find this document. I cannot find it. If anyone watching this video knows where I can find it, please let me know, either in the comments or if you're on Discord, you can include it there under the Scroll Docs tab. But I would love to cover every single document related to this trial, obviously. And unfortunately, I was not able to find this one. So Hill resigned. Well, we already know about this. So then this has to do with his federal appeal. So basically, that's the gist of it right there. So that's what's going on with that appeal regarding the after discovered evidence. But one of the updates, which is the reason I'm making this video, is regarding his initial appeal on the murder conviction. Of course, like I said, in the wake of that hearing, he wasn't granted a new trial. So now back to that initial clock on the murder conviction appeal. So Dick and Jim had requested to the appellate court that they continue to basically pause that clock, right? And give them more time to go through this whole process of his appeal. They were asking, can you please give us more time? And that motion was denied. And that's another document that I tried to find and couldn't find. So I've got two documents now that I would love to have. The first is the document with Dick and Jim filing a motion with the South Carolina State Supreme Court, and then the other is this one where they filed a motion to the South Carolina Court of Appeals regarding his murder conviction appeal. So that's all that, but we do have some other fun news. If you saw the thumbnail, a chainsaw and a deer stand. So what have we got going on here? So let's just take a look at this. So here we go from Bluffton today. Hampton Police Chief faces assault charges for using chainsaw to cut hunter's tree stand. So this is from August 2nd, 2024, so yesterday. The South Carolina Law Enforcement Division, Shadow Sled, said August 1st it has charged Town of Hampton Police Chief Perry McElhaney with assault and battery, 3rd degree, stemming from a hunting incident last November. So this was November of 2023, but he was just now charged as of, I think, August 1st. Right, yeah, August 1st. According to the warrant, which I've tried to find and haven't been able to find yet, however, this just happened, so that could be why. According to the warrant, on around November 4th of last year, McElhaney arrived at a Varnville. You guys remember that? Anyone who was with us for the Murdaugh deep dive, right? All roads lead back to the railroad. Insane. Of course, it's Varnville, right? Arrived at a Varnville property where he encountered a person hunting there in a deer stand and then accused that person of trespassing. The warrant then states that McElhaney retrieved a chainsaw and began to cut down the tree stand with the victim still in the stand. The victim, the warrant said, recorded the incident on his cell phone and provided the footage to SLED. The warrant states that the victim had received permission and paid approximately $500 to the property owner, which allowed him access to the property. The victim was not named in the warrant. And there's the SLED, whatever you call it, badge thing. Yeah. SLED stated McElhaney provided a statement to SLED admitting to attempting to cut the tree down while the victim was sitting in the deer stand, with the warrant stating McElhaney attempted to injure another person with the present ability to do so. Hampton County Detention Center Director Pam Smith said Friday that McElhaney was booked into the Hampton County Detention Center August 1st and processed. He was then released the same day on a $1,187.50 personal recognizance bond. And there he is. Doesn't he look like a nice fellow? So then, let's just take a look here. We have the Hampton Police Department. I mean, as of right now, it still lists him as the chief of police. I don't know yet. I mean, you know, he was released on bond. He's not in custody, so, like, I guess he's still available. So we'll see what happens. And there's a nice picture. And it looks like, I think this might be him right here. So there you have it. So, word on the street also, by the way, guys, is that the egg juror is going to be writing a book, or is in the process of writing a book. So there's that. Anyway, that's just the latest, just a short video updating you guys on what's going on. This was a funny story. Obviously, you know, all roads lead back to the railroad, right? Like I said. So that's it for now. And anyone who is following our coverage of the Wisconsin versus Ezra McCandless, first on YouTube ever, gavel to gavel trial with live commentary / legal analysis / squirrel analysis. We do have another live stream as of the day of this video. It'll be happening tonight. So anyway, but for anyone who's watching this at any point in time, if you're like, oh, what is that? There's a playlist for that trial, as with all of the trials that I've covered. So if you're interested, I highly recommend checking it out. It is a really, really interesting one that has kind of flown under the radar, and like I said, until now has never been streamed gavel to gavel with any type of commentary or legal analysis. So do check that out if you're interested. But again, I've got plenty of playlists y'all are welcome to check out. Do make sure that you're subscribed and have the notifications turned on, because we do live streams pretty regularly, I would say almost every day. And other than that, that's all for now. So thanks for being here. Thanks for being a squirrel, and see you guys on the next one.